van der Lange.
Hi, I'm Robin Shepherd.
Hi, I'm Nicoline Skuman-Low, and welcome to our podcast. We all practice as attorneys of the High Court of South Africa and do so at Skuman Law Incorporated, based in Cape Town, South Africa, where we proudly serve the legal needs of the entrepreneur. Today in our podcast, we are going to be talking about child maintenance. Robin, I'm going to hand over to you first. Dealing with child maintenance issues can often be an emotionally charged experience for the people concerned and often feel quite overwhelming to everyone concerned. Maybe walk us through the process. What does it entail?
Sure. So maintenance is a very sensitive matter. Both parties are usually involved, mom and dad, and essentially either party can approach a district court within their area. The maintenance court does operate separately from the children's court, so it's a specific court that deals with this. Each maintenance court also has maintenance officers and clerks of the court that are open to helping the public with applications or any queries that they have. Again, it is a specific court that deals only with maintenance queries. Yeah, and I'd like to ask you a question about the importance of maintenance in South Africa, and if you can maybe just dive into what it really entails for us.
So essentially maintenance in the South African legal context, in this context specifically in relation to child maintenance, it's important to remember that the High Court is the upper guardian of children in South Africa, and that means that any court that is below them will obviously look at the best interest of the child when determining issues such as maintenance. Now, what maintenance usually takes the form of is it's some sort of financial compensation or payments that are made from a parent to another parent in order to either maintain their children, or in that sense, you have to look at it from who earns the most in the family unit and who needs to compensate who in order to keep the standard of living the same from when the parents were together. But obviously that can also extend to parties who weren't married and require maintenance for a child born from the other parent. And in that sense, they would apply to court and they'd ask the court for a monetary amount in order to maintain that child. And the idea here is to obviously assist with the well-being of the child in that sense. But on that note, I'd like to ask you, Nicoline, how would you describe that you would exactly go about applying for maintenance in South Africa?
Well, from an application point of view, there's quite a lot of administration that actually goes into it. So attending any maintenance court would be anyone's first point of departure. Obtaining the necessary forms directly from court is possible, filling it into the best of your ability with all the relevant information. And then, of course, once that has happened, the court officials do assist the public and guide them in relation to completing those forms and collecting the supporting documents, detailing the financials, the details of the parties and the needs of the children, school fees, medical expenses, day-to-day, all of that. And once that has occurred, then usually there's a set down. In other words, there'll be a court date and there will be a process that will ensue from there. Now, of course, it goes without saying that an attorney can also assist in this process. And I really think that that's quite useful because firstly, the attorney would know their way around the paperwork, know what would be required, would make sure that the most relevant information is put together in the correct way. When this does not happen, although the officials are quite helpful in this court, that's been our experience, it does delay the matter, and often the expenses do not stop. Children need to go to school and fees need to get paid and all these things. So it is really important, I think, although it's quite administrative and it is possible to do it yourself, I do think there's some real value in just getting someone to help you put it together correctly from the start. Otherwise, it just becomes a back and forth. And at the end of the day, time has a real impact on your ability to take care for the child or the children concerned. Robin, I want to go deeper into the process. A court hearing in itself, particularly when it involves children, can be so overwhelming and possibly even intimidating. What is it that one can expect in this process?
Absolutely. So firstly, when you approach the maintenance court, and as you just mentioned, you filled out all the papers, you have a hearing, the maintenance officer will first step in as an intermediary, and the maintenance officer will really try to assist the parties to mediate the matter and to see if they can come to some form of settlement. Now, that could take, one appearance, it could take 2 or 3, but ultimately, if the parties do not settle, the matter will be set down at court. And during this specific hearing, it runs very similar to a normal civil trial. Each party, whether they are represented or not, will have an opportunity to present their case. Each party will also have an opportunity to cross-examine and re-examine, really ask the questions. Evidence will be allowed to be submitted naturally. That would be all your supporting documents, your financial statements, any receipts that you've kept, anything that can show the court why you either need maintenance or why you cannot afford to pay the maintenance. So it's very important that you have a documentary bundle to support your claim. And on that basis, you would also then do a closing argument. And unless a magistrate isn't too satisfied, a magistrate can step in during the proceedings to ask any necessary questions from either party. So the magistrate could maybe just want a bit of clarity on perhaps a bank statement that the magistrate is looking at. So it really varies, but ultimately it follows the normal civil trial basis. The matter will be closed on, let's say, day 1, and then we'll come back to court and the magistrate will give their judgment. And the magistrate will walk each party through why they've come to this specific decision, and an order will be granted. And on that basis, Johan, I know I've mentioned that there is documentary evidence that is provided for in court, but perhaps you could just tell us what are the different factors that the courts will take into consideration when determining maintenance.
So basically what the court will take into account is they look at mainly the income of the parties, what their financial obligations are, what the financial obligations are of their dependents. This could be dependents that are obviously involved, being the children here or other children from another marriage. People's lives vary and there's varying circumstances, and the court takes all of this into consideration and whatever you place in front of the court. The other thing that the court will also look at is obviously the standard of living of the parties and trying to maintain that as far as possible. So usually in these circumstances, should the court or the maintenance officer be suspicious that either party isn't being truthful or that they're trying to, obfuscate their financial position, in those circumstances, they can subpoena certain records if they're not providing them willingly. And there are various steps that can be taken in order to ensure that all the information is in front of the court. The court also sometimes considers all special circumstances that may require additional financial support, above what would normally be required. This could be things such as the educational needs of a child with special needs, or medical expenses for a child that may be sickly, or isn't covered by insurance. And that's why it's very important to, note that each case is extremely unique, and the court will look at each case based on its own merits and circumstances and what evidence is presented before the court before they determine a maintenance amount. So it's important to always place whatever information is relevant in front of the court. But Nicolene, I'd like to ask you, what options do you think are available for enforcing a maintenance order once one is actually granted?
Yeah, I think that's getting your orders is one thing, and we've now gone through the process. It can become quite an intimidating, extensive process with lots of information being exchanged. The information may even be questioned. But as we get to the end of the line, the next problem sometimes tends to rear its ugly head, which is now we've gone through the whole process, we have our order, but the payments are still not coming in. Now, first and foremost, the maintenance officer, as that designation itself, is there to assist parties with steps such as subpoenaing records, garnishing orders against banking accounts, and so on. So I would say that's your first point of call, particularly if you are running this as a private person without the assistance of an attorney, is to seek that assistance and support. If that does not yield the desired result, then we are back in the normal course of executing judgments. Now, interestingly, just a few years ago, there's been a movement that if you are not paying your maintenance in terms of a court order, you can actually be blacklisted, or an adverse credit listing can be listed against your credit record. That was a huge step, particularly for parents that have these orders, but they never see the money. And that means it becomes publicly known that you have a child or children, there's an order for you to maintain them financially, and you are not doing that. That will make the ability of accessing credit really difficult for that person being guilty of something like that. That listing usually lasts for a period of 5 years, and it can only be removed by consent of the person who listed it, which would be the other parent who got the order. So that is recourse that is available, and I think that's a step in the right direction. We have a lot of parents that default on maintenance, and quite frankly, personally speaking, I feel it's quite shameful. If that also doesn't get us to the point of the payments starting to happen, then of course we can go into the execution process, being a Section 65 inquiry, a emoluments attachment order. It depends on why the payments are not happening. If it's just completely a case of not corresponding, not engaging, then it would probably be better to try, if you know that your ex-spouse or partner, the parent who's defaulting, is employed, an emolument attachment order against the salary would be a good first step, because then at least the employer makes sure that the deduction gets made and paid over. Alternatively, we can always attach bank accounts, and there are other forms of methods that one can explore. But that would be a good, I think, starting point. Now, we've spoken a lot about the court process and all the things that can happen, but Robin, specifically, we've seen the court rules making accommodation for court annexed mediation processes and other forms of dealing with this. Maybe let's end off talking a little bit more about what those options are.
Of course. Of course. So the other option is naturally mediation. And mediation, as I've mentioned, that usually happens before the actual hearing. And that's really in instances where you're talking with the maintenance officer themselves. However, you can do mediation outside of maintenance court as well, whether you're represented or not. Parties can sit together in a round table and perhaps come to some form of an agreement. Again, it takes the intensity of a maintenance hearing out of it, and parties are a bit more able to see what the other side is able to bring to a maintenance settlement agreement without the extreme emotions behind it, because it is a very sensitive matter as well. But it is very important to approach legal representation as well if you're unsure of the actual legal process, if you're unsure of the mediation process, and if you're unable to obtain financial assistance from the other parent or spouse, it's important to note that you are able to approach different family members. However, that is something that we do suggest you use legal representation for, because that becomes a bit more critical. So there are alternatives to going to maintenance court, but it is best to approach a maintenance court if you're in need of financial assistance.
I cannot agree more. Mediation is in many instances seen as a weak approach in inverted commas. I cannot stress enough that I don't agree with that. I recently heard someone mention or comment on the perception against mediation, saying that at some point we cannot resolve things between ourselves, but yet we go to court where there's very little about the process that we are actually in control of. Then we have so many moving parts that ultimately the enforcement of your rights becomes extremely challenging, whilst the mediatory process just helps you reconnect and be more in control of the process outcome in itself. We don't have so many moving parts. And often that mediator, particularly a well-experienced mediator, will just help us speak to one another in a constructive manner and actually hear what both parties' perspectives are and why they are taking the position that they are, so that we ultimately get to the point, and Johan mentioned this when we started off, that it's always about what is best for the child or the children concerned. And somewhere along the line, we seem to lose the plot sometimes on these issues, but mediation particularly, I think, is a very useful tool. It's much quicker, it's much more cost effective. And if we engage with a seasoned mediator, I think there's a lot more control in how this actually pans out. And often from a cost point of view and actually getting your maintenance payment, that is actually a very, very important consideration. So to perceive it as being a weak process or, heeding to the other party in a power play struggle, I think is utterly misguided. But thank you everyone for joining us today, for spending your time with us. We know it's precious. Please like, comment, share in the box below if you have any comments, questions, maybe even experiences that you would like to share with us. We would really appreciate that. Please connect with us on our social platforms. We're on LinkedIn, we're on YouTube, of course. If you are watching this video, that's where you are. Please subscribe to our channel and do follow us on Facebook for the latest updates. We also publish quite widely on our website and on external platforms. So keep a lookout, subscribe to our newsletter, and stay informed with the latest legal provisions.